My name is Jonathan Ackerman, and I want to briefly introduce myself. I'm a tax attorney with a Master of Laws in Taxation from Georgetown University Law Center. I've been practicing for just over 25 years, and I've been working with a number of different exempt organizations, both public and private charities and other exempt organizations. And what I do is I help them in their creation and in their governance, in tax qualification issues and tax compliance issues. The essence of the conflict of interest policy is we're trying to flush out any type of business arrangement between the fiduciaries or insiders and the charity. Now remember, this correlates with the fiduciary's duty of loyalty. The fiduciary has to act in good faith and in the best interest of the charity rather than in their own personal interest. So that's the context for this entire policy. Now, conflicts of interest are very common and sometimes inherent in local arts organizations where local artists are members, or members of the board. So that is perfectly viable and appropriate to have in a nonprofit organization. And also keep in mind that just because an insider, what we call a disqualified person, and we're going to somewhat meticulously walk through that definition, has a direct financial interest in a transaction with the charity, that's not inherently bad. Even the IRS good governance practices recognizes that a disqualified person should avoid a conflict of interest that is detrimental to the charity. Okay? But what has to happen is certain procedures have to be followed once a conflict of interest is identified. Let's talk briefly about the IRS sample, which I include in your policy packages. But let's talk about the differences of what we've done with the policy that I'm recommending to you all. First, the IRS sample focuses on a financial interest only. And of course, you'll notice within the policy that it's broader than just financial interests. It's like, does the board member play a fiduciary role with another charity that either receives support from or may be entering into a transaction with the charity? Also, the IRS sample doesn't include the definition of a key employee, which pursuant to the instructions should be included in the conflicts of interest policy. And the instructions I'm referring to are to the Form 990. And lastly, it doesn't include a definition for a person with a substantial influence, which relates to the Code Section 4958 excess benefit transaction. And also what I do in my recommended policy is I have much more detail to the due diligence process. But I will say that I use the IRS sample as the basis, as the platform to move forward into these other areas. If there's anything you want to walk away from understanding with regard to the conflict of interest policy, is that you have to have disclosure, which I'll talk about in a little bit, disclosure of a conflict or a potential conflict. And secondly, you have to lay out the due diligence procedures in the event you identify a conflict of interest.